So last time we met in company law, we started discussing the theory of incorporation, and especially we look at the legal consequences or effect of incorporation. We did note that once the company has duly been incorporated, it is signified by the issue of certificate of incorporation. And in the eyes of the law, it becomes a legal person. It can enter into contract in its own right. It can sue and be sued. It can own its own properties, as it were. So that is what we call like the theory or the view of incorporation. And we discussed the case of Solomon and Solomon, and we asked you to read the other cases which have been cited. So this morning, we want to look at the other side, the flip side of the coin, lifting the veil of incorporation. Or some scholars would say like the piercing, the veil, and all that. So the point to remember is that when the company has only been incorporated, in the eyes of the law, there's a metaphorical veil, that imaginary veil, which has come to, cover or envelop the company so that the officers of the company, the shareholders of the company, the incorporators of the company are not seen, but it is a company which is seen in its own right, which is seen as a distinct on its own. So that is the entity doctrine. And we noted the case of Solomon and Solomon actually underscored that. And I'm very confident that you have read that case by now. So Solomon and Solomon emphasize that once the company is duly incorporated, it is separate and distinct from its members and officers. And with that matter, in the eyes of the law, a figurative veil, that is an imaginary veil, comes to envelop the company to separate it and distinguish it from the persons who may be behind it or who may control it. However, under appropriate circumstances, the law may ignore the separate legal personality principle and ascribe liability to individuals who are involved in the affairs of the company. So ordinarily speaking, when the company is involved in anything, it is a company which should be held liable, the company which should be held responsible. Nevertheless, there may be situations in which, for good reason, the law says that we should not just look at the company. We should be interested in persons who were in charge of the company when the company actually did something or failed to do something. And let us hold those people who were in charge responsible. So when it happens that way, is that we have ignored the separate legal personality principle and are trying to deal with individuals. So we have lifted the veil. Now, when you lift the veil, you'll be able to see those who are behind it or those who are inside. So when the veil is lifted, you see true individuals that might have done something or omitted to do something, and then they are held liable or accountable, as it were. So that is the essence of lifting the veil or piercing the veil as it is. And if we wanted to clarify that concept further, we will benefit from the words of Sophia Kufu GSC, as she then was in the well-known case of Mookwe and Kuma. We touched on Mookwe and Kuma too at the last class. Her leadership rendered herself as follows, quote, the corporate bearer between the company and the persons who constitute or run it may be breached only under certain circumstances. These circumstances may be generally characterized as those situations where, in the light of the evidence, the dictates of justice, public policy, or the Companies Act so requires. It is not possible to formulate an exhaustive list of circumstances that would justify a lifting of the corporate veil. Yeah, so that sums it all. That yes, the veil may be ignored, and it may so be ignored in order to advance justice or in order to satisfy the requirement of public policy. Or it may well be that the Companies Act or some even other legislation has prescribed that the veil should be lifted. And similarly, we look at the case of Worldwide Shipping and Agencies Limited. Similarly, if you look at the case of Worldwide Shipping and Agencies Limited against DACO, the Court of Appeal made a similar point that, quote, a corporation will be looked upon as a legal entity as a general rule. But when the notion of legal entity is used to defeat public convenience, justify wrong, detect fraud, or defend crime, the law will regard the corporation as an association of persons and not as an entity, so to speak. So, in those situations, in such cases, the subject company will be held to be the alter ego of the shareholders, the officers of the subsidiary company. We have already seen from Moko and Kuma the driving factors for lifting the veil, requirements of justice, public policy, or even the Companies Act. Now, when we strictly adhere to the separate legal personality principle, it may sometimes lead to inequitable results, and for that matter, create injustice to the creditors of the company or to minority members and even to the republic. So if you look at plethora of cases, including Majob and Co. Limited against Bartholomew and Co., the case of Grant and Tikobo, and then Hanjemi against Jabil Brothers, they all illustrate how the principle of separate legal personality may be sidestepped so as to avoid injustice to company creditors or minority members and even the state. So I will encourage you to look at the short article, just a few pages, about 9 pages. Companies and Creditor Rights, Solomon and Solomon, the Ghanaian Experience. You can find it in the 1973 Review of Ghana Law Report and Review of Ghana Law. You can find it either on your Law Finder or any of those platforms. So you go to the library and then you locate it. Now, as we have indicated already, when the veil is lifted, the separate legal status of the corporation is disregarded, and certain consequences follow. It may well be that individuals will face civil liability, or they may face criminal or penal liability by way of fine or imprisonment, as the case may be, or tax liability may be ascribed to others, or it may be that certain transactions which had apparently been entered into by the corporations will be nullified or disregarded because the veil has been lifted. So as we have said, in summing up, we could say that the corporate veil may be lifted by one of the following three ways, namely, by the Companies Act 2019, Act 992 itself, by other legislation, and by the courts. So let's look at these thematic areas, these scenarios in which the veil may be lifted. So lifting the veil, first one to the Companies Act. Now the veil is said to have been lifted, as we have explained, when the act permits individuals and related companies, maybe such as subsidiaries, parent companies, or fellow subsidiary or joint parent company, or a subject company to be held responsible, whether or not jointly with the subject company, as done by or in the name of the subject company. So, what are instances in which the Companies Act, Act 992, permits the veil to be lifted? We are going to give you examples. You can identify so many examples on your own by looking at Act 992. So, for example, if you look at Section 41, Section 41 says that where last time we read it, and then we compare it with even like the old provision, that where the company carries on business without any member, then any debts and liabilities that are incurred will be borne by those that presided over the company when it's run without any member. So look at Section 41. And again, where a company carries on business for more than 4 weeks after the number of its directors falls below 2. You know, the law is that a company must have a minimum of 2 directors. And Section 171 is telling us that if the number of directors should fall below 2, and you continue to run a business using the company for a period exceeding 4 weeks, then those who presided over the company when the company was running with less than the minimum number of directors will be made to bear personal liability for any debts or liabilities that may occasion during the period that the company ran with less than the minimum number of directors. So let us keep that in mind. Then also, where there's an error or omission in a document containing particulars delivered to the registrar under Section 13, the company and every signatory of the company is liable to pay to the registrar an administrative penalty of 150 penalty units. So if you look at Section 17, it illustrates that. Another example, where a company limited by guarantee carries on business for purpose of making profits other than profit for the furtherance of the objects of the company. the veil will be lifted, and those who were in charge of the company will be made to bear personal liability for any debts which will be occasioned. So see section 8, subsection 2. Again, where there's a failure to publish the name of the company on its description, somebody should read section 125 for us. Section 125, who wants to read it so that I will release your mic for you? Section 125. Whose hand is up? Okay, Elizabeth. Elizabeth, and then I'll go. Okay. Read the readers.
Section 125. Publication of name of company. Subsection 1. A company shall A. Paint or affix and keep painted or affixed the name of the company on the outside of the registered office and of every office or place in which the business of the company is carried on in a conspicuous position in letters that are easily legible. B. Where the company has a common seal, have the name of the company engraved in legible characters on the seal. And C. Have the name of the company accurately mentioned in legible characters at the head of the business letter, invoices, receipts, notices, or any other publication of the company, and in the negotiable instruments or orders for money, goods, or services purporting to be signed or endorsed by or on behalf of the company.
Okay, are you done? Arida, are you done? Oh, you didn't finish. We lost him. Yes, okay, I'll go. You can continue. You need a subsection 2. Subsection 3.
My lord, section 125, 2, 2.
Yes.
Where a company defaults complying with the subsection 1, the company and each officer of the company that is in default is liable to pay to the registrar an administrative penalty of 250 penalty units. 3. Where an officer of the company or a person purporting to act on behalf of the company uses or authorizes the use of a skill purporting to be a skill of the company on which the name is not engraved as required by subsection 1. Such officer commits an offense and is liable on summary conviction to a fine of not less than 100 penalty, 125 penalty units, and not more than 250 penalty units.
Okay, all right, thank you. So what we are saying in section 125 is that, yes, the law requires the company to properly publish its name at the business premises, on its business circulars, letterheads and all that. And also checkbooks, the negotiable instruments, and also its seal. So these are matters which are for the company. However, if they are not done properly, or even if they are not done at all, it is not the company which is just targeted. Individuals, officers who were responsible to get it done for the company but did not do, they will be identified. So the veil will be lifted. We try and find out who did what or who did not do what. and they will be made to bear personal liability by way of paying fine, as we have just been told. So please look at the cases of Cowries Finance Limited against Parku Bay Seafood Limited to illustrate the failure to publish the name of the company name in description, as we have discussed. And again, where the Register of Companies has directed that we change the name of the company, and you fail to do that, the veil of incorporation may also be lifted. So we'll read section 21, subsection 5, 6, 7, 8, and 10 for us. Subsection 5, yes. Okay. Yes, I'll go, yes. Yes, go ahead and read.
Yes, my lord. Section 21. Names of companies. Section 21.1. The last word of the name of a company. The name of A, private company limited by shares, shall be limited company, or the abbreviation LTD in caps. B, public company limited by
No,
shares
please.
shall be.
I'm talking about the subsection 5. 21.5, subsection 5, subsection 6.
Yes, my lord. Yes, my lord. Subsection 5. Where through inadvertence or otherwise a company on first registration or on registration by a new name is registered by the name which, in the opinion of the registrar, is misleading or undesirable, the company shall change the name of the company with the approval of the registrar. 6. When the registrar so directs within 6 months of the company being registered by that name, the company shall change the name within a period of 6 weeks from the date of the direction. Subsection 7. When the registrar is of the opinion that by reason of a change in the object of or the nature of the business carried on by a company, the name under which the company is registered is misleading or undesirable, the registrar may direct the company to change the name, and the company shall change the name within 6 weeks of the direction, unless within that time the company has lodged an appeal to the court against the direction.
Go to the 10.
Subsection 10. Where a company defaults in complying with the direction under subsection 5, 6, 7, or 8, the company and any of the directors of the company that are cognizant of the default are liable to pay to the registrar an administrative penalty of 25 penalty units and a further penalty of 50 penalty units for each day that the default continues.
Okay, good. So we see another example where the veil is lifted and we try to identify which officials are responsible for not complying with directive of the registrar regarding change of name, and then they will be punished as individuals and not the company being punished, as it were. So can you identify more examples in the Act where the veil has been lifted? So I want 5 students to give me 1 example each, apart from the one that we have discussed together. Apart from the ones that we've discussed in this class today, I need 5 other examples. There are a lot of them, yes. Make sure that only one person has his mic on at a time. You can unmute yourself, but only one person at a time. I'm waiting for you. So you mentioned like the provision, like the session this, we have this example, yes. I'm not talking. Maybe I'm not talking. Let's continue. So lifting the veil by the courts. If you look at how the veil may be lifted, first one to provisions of, let's say, the Companies Act itself. Now, quite apart from that, as Moke and Kuma were told that the court will pierce the corporate veil in order to enable it to do justice by treating a particular company for the purpose of litigation before it as identical with the person or person who control it. This will be done only where there is fraud or improper conduct. But in all cases, where the character of the company or the nature of person who control it is a relevant feature, in such cases, the court will go behind the mere status of the company as a separate legal entity, distinct from its shareholders, and consider who are the persons as shareholders or even as agents directing and controlling the activities of the company. Yeah, so Moke and Kuma has given us the broader scope and the blueprint on basis of which the court may lift the corporate veil. Similarly, if we look at the more recent case, of course, not that recent, but 2013, pressed against Petroder Resources, a decision of the UK Supreme Court, a very interesting case. And I would like all of you to read the full judgment of Press and Petroder Resources Limited. It's a case which was originally like a matrimonial case, like a divorce case and all that. And the court had made certain orders in terms of property settlement. But to be able to get all those things done, we needed to trace the assets of the man, and the man had a number of companies having all the various assets, and it was difficult to find out which were his personal assets. So I will not say much, but I'd like you to read the case of Press against Petroder Resources Limited. And in that case, Lord Sampson will make a point similar to what we had witnessed in the case of Mooko and Kuma. So Lord Sampson made a point that, quote, the corporate veil may be pierced only to prevent the abuse of the corporate legal personality. The court may then pierce the corporate veil for the purpose and only for the purpose of depriving the company or its controller of the advantage they would otherwise have obtained by the company's separate corporate personality. Yeah, so here, the long line of case law, the common law, associated with lifting the veil is being summarized by his lordship, that yes, the veil will be pierced if it's being used, that is the separate legal personality is being used to deprive the company or the whoever controls it, if it's being used to indulge in abuses or to overreach the company, as it were, then the court will ignore that principle in order to find out the rare human beings who are in charge and hold them liable. Now, there's the case which I will encourage all of you to read, apart from Press and Petroleum Resources. That is the case of Adams against Cape Industries PLC. Very interesting case. So, based upon all that we have said, what is the criterion, the test, which will be used by the court in lifting the veil? So the court must ask itself, will the corporate veil be abused in the circumstances before the court if the court does not ignore it? If the court does not lift the corporate veil, will it be abused? Or maybe put it differently, is the corporate veil being abused? And for that matter, it must be disregarded. It must be sidestepped in order to check the abuse. And that is why in Mokwe and Kuma, so for Akufu JSH, it then was to make the point that whether or not a situation is one in which the lifting of the veil of incorporation is merited is dependent on the peculiar factors driving each particular case. So let us keep that in mind. So we cannot have an exhaustive list of situations in which the veil will be lifted. The nuances, the details will have to be worked out on case-by-case basis. And that is why she's making the point that as whether the veil will be lifted or not is dependent on the peculiar factors driving each particular case. So the court will only proceed to lift the veil if the question is answered in the affirmative. So let's look at some practical situations where the court lifted the corporate veil to prevent actual or potential abuses. For example, you look at the case of Trustor AB against Morborn, number 2. In that case, the judge, Sir Moritz, held that the authorities under English law justify the piercing of the veil in 2 possible overlapping cases. 1, where the company was facade or sham to conceal true facts, thereby avoiding any individual liability. And or 2, where the company was involved in some of impropriety that actually or potentially abuses the corporate veil. So please, if you read Press Against Petroleum Resources, the court actually did a survey of the various case law in which the veil has been lifted. And the court tried to extract the relevant principle. And that is why I would like you to read the full judgment of Press Against Petroleum. So, Moka and Kuma are along the same lines. So they say that the corporate veil will be pierced where 1, there is fraud, 2, there's improper business conduct, 3, there's willful misdeeds, for evasion of contractual obligations, and where the details of public policy and justice requires it. Now, as you read the cases, you will come across words like facade, like sham, especially if you read the case of Solomon and Solomon. Even those words were being used as far back as that time. So facade here denotes outward appearance, especially one that is false or deceptive. So if they say that, yes, the company is just being in a facade, that is to say that the company is just being used as a cover, and for that matter, the legal personality principle should be ignored. And again, it also suggests pretense and concealment, so that the fact that the incorporators of a company have complete control of the company is not enough to constitute the company as a mere facade. So before we can say that the company is a facade, mere facade, we must also find out whether there's concealment, whether there's an attempt to conceal maybe some wrongdoing using like the company. And that is why in Charment against official trustee in bankruptcy, that's this Lockhart. This is a decision from the US. We make the point trying to explain the term sham, because sometimes as you read the case law, you'll be coming across those kind of things, that the company is a sham, it's a mere facade, it's an alter ego and all that. So sham, he explained it as, quote, something that is intended to be mistaken for something else, or that is not really what it purports to be. It is a spurious imitation, a counterfeit, a disguise, or a false front. It is not genuine or true, but something made in imitation of something else, or made to appear something which it is not. It is something which is false or deceptive. So when we say sham, that is how he tried to explain it. And similarly, in Press Against Petroleum Resources, the words which are often used when consideration is being made as whether the veil should be lifted or not, we come across facade, sham. Lord Sampson was at pains to explain what they actually mean in the context of lifting the veil, separate legal personality and all that. So I quote the decision of Lord Sampson in Press Against Petroleum Resources, quote, references to a facade or sham beg too many questions to provide a satisfactory answer. It seems to me that two distinct principles lie behind these protein terms, and that much confusion has been caused by failing to distinguish between them. They can conveniently be called the concealment principle and evasion principle. The concealment principle is legally banal and does not involve piercing the corporate veil at all. It is that interposition of a company or perhaps several companies so as to conceal the identity of the rare actors will not deter the court from identifying them, assuming that the identity is legally relevant. In these cases, the court is not disregarding the facade, but only looking behind it to discover facts which the corporate structure is concealing. The evasion principle is different. It is that the court may disregard the corporate veil if there is a legal right against the person in control of it, which exists independently of the company's involvement. And the company is interposed so that the separate legal personality of the company will defeat the right or frustrate its enforcement. So his lordship was trying to tell us that there are times that the veil may not need to be pierced or lifted, so to speak, but it will be enough just to peep, just to look behind it, to find out certain things. So in that regard, where there's an attempt to conceal, so that's the concealment principle. But then where people are trying to run away from certain obligation or from certain things, but still using the company vehicle, then the veil will be lifted or be pierced. So where there is fraud, the court will lift the veil and treat the company as a facade or sham. So let's keep that in mind. And that is why in Lazarus Estate Limited against Belsley, Lord Dunning will make the point that, quote, no court in this land will allow a person to keep an advantage which he has obtained by fraud. Fraud unravels everything, and the court is careful not to find fraud unless it is distinctly pleaded and proved. And once it is proved, it vitiates documents, contracts, and all transactions whatsoever. Yeah, so the point being made is that when it comes to fraud, it is one fertile ground on basis of which the veil will be lifted. Please look at the cases that we have provided. Amate against Social Security Bank Limited, and then Robertson consolidated case, and then Moko and Kuma itself, Cowley's Finance Limited, Ray Burglary Price. Please read those cases and brief them. And again, for the evasion principle, where a person is trying to evade his contractual obligation using the corporate vehicle, look at cases of Guilford Motor Company Limited and Home. Very interesting case. Then Jones against Lipman, Crazy Bridgewood, and Odd and Belhaven. And let me give you this is a simple thing. From your law of contracts, we have contract in restraint of trade, where a person is given employment, and as part of the employment, there is a clause to the effect that he or she is not supposed to accept, or maybe let's say like typical, like when it comes like, let's say like a sale of a business, okay? Maybe a business is sold, and then there's a clause in it that within a certain period, similar business cannot be commenced within a certain parameter or certain geographical radius. So that agreement is made. You get the person who has obligation not to compete with the purchaser of the business, setting up a new company and allowing the new company to do that which he had contracted not to do. And then when you complain, you say that this company is separate from me. So here, you are trying to evade your contractual obligation not to compete. So please look at the case of Guilford Motor against Horn. It's a very interesting case. Sometimes when it comes to agency arrangements, the court may also find it necessary to lift the veil and come to conclusion that the company is in fact an agent of another entity and not a principal in the purported transaction. So look at the case of, especially the case of Ray FGA Firms Limited, and also the Ghanaian case of Kuni against the State Gold Mining Corporation and another. Public policy and justice, as we have noted, would also provide the basis for lifting the corporate veil. Now, lifting the corporate veil on basis of safeguarding public policy, advancing justice, will require that some impropriety, according to the particular factual scenario before the court, has been identified. And in order to remedy that impropriety, it's necessary to ignore the separate legal personality principle. So where that is the case, then the court is not free to look on unconcerned. But the reverse is also true, that where there's no impropriety, the court cannot just go about ignoring the separate legal personality principle and say that in the name of justice, because if you are to play the justice card, right, so hard, then what it means is that the court can, at will, be ignoring the separate legal personality principle anytime. No, that is not it. And I've given you a case I did some years ago as an illustration, if you remember, I told you in the classroom, involving the Ghana Vineyard Plywood and the Forestry Commission, the Ghanaian who supplied some things. I told you about it, how a judgment was obtained, but the Ghana Vineyard Plywood was just existing in the books. It was no longer operational, so it did not have any assets. But it was also established that I think the Forestry Commission also had about 100% shares. But one who have said that, then go and enforce the judgment against the Forestry Commission, which has got so many assets. But that could not be done because of the principle of separate legal personality. So we are saying that we cannot just hide behind, I want to do justice, just in vacuum, in order to be lifting the veil. No, there must always be a distinct impropriety, for which reason justice will require that you lift the veil. Then when it comes to the phenomenon of a group of companies, we are talking about associated companies, you know, where we have like the parent company, subsidiary companies. So technically, each of the companies within a group of companies is a separate legal personality, okay? So if you have 5 companies which are related, and then we call that like a group of companies, we have like the parent company, subsidiaries, and all that. Now, as far as the law is concerned, each of them is distinct. And for that matter, if, for example, let me give you this illustration, like you have a company in a certain industry. Let's say the company has the mining concession. Another company provides the machines for the mining. Another company recruits the staff and manages them. And if we look at the share structure and all that, it's like almost the same shareholders for all those 3 or 4 companies, playing various aspects of the rules in, let's say, the mining activity. So let's suppose that something goes wrong and you sue the particular company concerned. Can you target the whole group? So those are the kind of things that we are looking at. And there are a lot of interesting case law which illustrates that. And you can only appreciate it if you go and read the case that I've said you should read. So please, read the case of Kuni against State Gold Mining Corporation, and also the Abazaro, as well as Bank of Tokyo. And that if you not read any case at all, please read the case of DHN Food Distributor against Tower Hamlets. One Lord Denning called like the Trinity doctrine or the Trinity case. Very interesting. I'd like you to read that. But despite the fact that the companies within the group of companies, as we have indicated, are separate and distinct from each other, it may be necessary in some cases for the court to ignore the separate legal personality and treat them as one company by applying one of true overlapping theories. For example, one, where the business of the subsidiary and that of the parent company is treated as a single economic venture. What we call the single economic venture theory, also known as the commercial reality theory. And if you look at the case of DHN against food distributors against Tower Hamlets London Borough Council, that is a very good illustration of what we are talking about, where you have, I think, three related companies. And if you look at the business that they were doing, food distribution, one company was responsible for the vehicle which were used. Another was responsible for the land or the property on which the company was operating from. So there's a wholesale cash and carry grocery business, which was run from a premises owned by a subsidiary of DHN, and that subsidiary is called the Bronze. So this subsidiary company had the same directors as directors of the DHN food distributors. But Bronze Company, apart from owning or being the owner of the premises on which DHN food distributors were operating from, did not carry on any business. So more or less, it was set up just to acquire and own that premises. The only asset was the freehold properties, which DHN food distributors occupied as its licensee. Now, there was another wholly owned subsidiary, and that subsidiary owned only vehicles, that is the cars or the trucks, used by DHN food distributors in its business. And apart from owning the vehicles, it did not carry on any business. So if you look at it, the first subsidiary, Bronze, all that it owned was like the premises, like the building. It didn't carry out any business. And the building was where DHN food distributors were operating from. And again, another subsidiary, which is also wholly owned by DHN, it also owned the vehicles which were used by DHN to run the business. And apart from owning the vehicles, it did not do any activity, did not do anything again. So in 1970, there was a compulsory acquisition of the premises on which DHN was operating from. And mind you, the owner of the premises is not DHN, it is Bronze. But DHN is more or less the owner of the subsidiary called Bronze. So when the compulsory acquisition occurred, DHN had to close down its business because the property on which it was operating from had been compulsorily acquired by the state. And there was the need to look for substantial compensation. But this compensation had already been paid to Bronze, which owned the premises. And later on, DHN, which had to close its business, thought that no, it needed to get the compensation because a business had been closed and because of the compulsory acquisition. So it took up the matter. But before you can claim compulsory acquisition, before you can claim compensation for compulsory acquisition, you must have interest in the land which has compulsorily been acquired. And the facts indicate that you were just DHN more or less was a bare licensee. Remember your landlord was a bare licensee, and for that matter, was not entitled to compensation. So this was the ruling of the Land Tribunal. So the company appealed the decision to the English Court of Appeal, and the English Court of Appeal, speaking through Lord Justice Shaw, with whom Lord Denning, Master of the Rules, concurred, had the following to say, among other things, which I quote. There is a further argument advanced on behalf of the claimants that there was complete identity of the different companies comprising the so-called group, that they ought to be regarded for this purpose as a single entity. The completeness of that and the identity manifested itself in various ways. The directors of DHN were the same as directors of Bronze. The shareholders of Bronze were the same as in DHN, the parent company, and they had a common interest in maintaining on the property concerned the business of the group. If each member of the group is regarded as a company in isolation, nobody at all would have claimed compensation in a case which plainly calls for it. Bronze would have had the land, but no business to disturb. DHN would have had the business, but no interest in the land. In this alter identity and community of interest between DHN and Bronze, there was no flaw at all. As Bronze did no trade and carried no business, it had no actual or potential creditors other than its own parent, DHN. The directors of that company could, at any time they chose, have procured the transfer of the legal title from Bronze to itself. Mr. I again considered that if they had gone through the former operation the day before the notice to treat was served on 12 October 1970, they have had a secure claim for compensation for disturbances. Accordingly, they could in law have sought and obtained whatever advantages were derived up to the date from a separation of title and interest between the two companies and still quite legitimately have redisposed matters. They could not have been criticized, still less prevented, if they had chosen to do so. Yet the decision of the Land Tribunal be right. If the decision of the Land Tribunal be right, still less prevented if they are chosen to do so. Why then should this relationship be ignored in a situation in which to do so does not prevent abuse, but will on the contrary result in what appears to be a denial of justice? If the strict legal differentiation between the two entities of parent and subsidiary must, even on the special facts of this case, be observed, the common factors in the identities must, at the lowest, demonstrate that the occupation of DHN would and could never be determined without the consent of DHN itself. If it was a license at will, it was at the will of the licensee, DHN. the license subsisted. Accordingly, it will have gone on for an indeterminate time. That is to say, as long as the relationship of parent and subsidiary continue, which means for practical purposes, as long as DHN wish to remain in the property for the purpose of the business. So the court was trying to say that if you look at the close relationship between the three companies, the parent company, DHN, Bronze, and then the other company, yes, you may say that DHN was a licensee, like just permitted to be on the land by the owner, Bronze. But the court was saying that who were the directors of Bronze? The directors of Bronze were the directors of DHN. And for that matter, they can take a decision that Bronze should even transfer ownership to DHN. And that is why the court was the view that despite the fact that, ordinarily speaking, companies within a group of companies as parent companies, subsidiary companies, are legally distinct from each other, having regard to the commercial reality, how their business and things were. In fact, the court could ignore the separate legal personality principle and treat them as a single economic venture, in which case DHN will be able to get compensation as a result of the compulsory acquisition. Again, where the subsidiary company is an agent of the parent company, as happened in the case of Kuni against the State Gold Mining Corporation, where the court held that under the ordinary rules of law, a parent company and subsidiary company, even 100% subsidiary, were distinct legal entities, just like the one we'll be explaining. However, there was no rule of law which said that a company could not and should not act as an agent of its holder. And for that matter, the court came to the conclusion that Prestige Goldfields Limited were the agents of State Gold Mining Corporation and carried on its business. So I would like you to read that judgment, and you notice that before the court came to conclusion, it paid attention to ownership of the subsidiary profit, control and governance of the subsidiary company, which is a bit similar to, if you like, the reasoning of Lord Justice Shaw in DHN case. Again, where the corporate structure of the group is used as a channel to avoid liability for some form of impropriety, then the court will lift the veil so that the appropriate liability will be borne. So look at the case of Adams against the Cape Industries. It's a very interesting point. Just like our own recent AG Fund Construction Limited against West African quarries. Now, when it comes to interpretation of contracts and other legislation, it may also be necessary for the bill to be lifted as it were, depending upon the particular circumstances. And all these things we are saying are consistent with the observation by Sofia Kufu JSC in Moko versus Kuma that we cannot give a complete list. We cannot give an exhaustive list of situations in which the veil will be lifted. We're only giving, if you like, representative examples, as it were. So when the veil is pierced or lifted, what remedies are available? No, if, for example, it's about you trying to evade contractual obligation, injunction can be granted to restrain you from trying to evade your contractual obligation. So we are moving into a new area now, unless you have some questions. Then it's now, okay, we have a bit more time. Yes, let me stop this.